The names of bastards. There is a very popular idea that the surname of a bastard is that of its mother. The supposition is absolutely erroneous. A bastard is filius nullius, and in the eye of the law no more the child of its mother than the child of its father. It has no surname at all by inheritance. It must acquire a name by repute, that is, it must, theoretically, wait until the popular reputation of neighbors, acquaintances and others has conferred a name upon it. What period must elapse before such a name, acquired by repute only, can crystallize into a heritable possession? No one can say. For the ordinary purposes of life a comparatively short period will suffice. But when one comes into contact with the Crown's authority and prerogative in such matters, the question is on a different footing. We have known the necessity of a royal license insisted upon in the third generation. It is difficult in attempting to deduce a rule of practice from known precedents, however, to decide how much differentiation should be made on account of cases dealing not only with the name, but also with the arms. By the technical rules of the science of armory, a royal license is obviously essential before a bastardized version of a coat of arms can be exemplified. And on this account many precedents of non-recognition may need to be discarded as precedents, if considered as precedents to be regarded, in reference to changes of name only. On the other hand, precedents of recognition of a name may obviously be nothing of the kind, for the Crown may have had no knowledge of the real facts. Many precedents we are aware of are obviously discounted for that reason. The absurdity of the supposition that a child inherits its mother's name is flagrantly apparent if the case be considered of the bastard child of a widow or married woman. In such a case the child, under the popular idea, would be and often is saddled with the name of the previous husband of the mother, the very person who had nothing to do with its birth, and from whom the child derives not an atom of blood descent. The matter is best evidenced in the case of the bastard child of a widow, for, of course, a child born in wedlock is presumed to be legitimate, and legally inherits the name of its mother's husband for so long as that legal presumption legally continues. But the fact that a child not born in wedlock does not inherit its mother's surname cannot be too widely known, for, unfortunately, clergymen of the Church of England are much given to enforcing upon a bastard child the use of the name of the mother. A scandalous case of the kind occurred within the knowledge of one of the writers. A child was born shortly before the marriage of its parents, but the circumstances of its birth were such that its illegitimacy was absolutely unknown to the outside world, and the child grew up to adult years known, as, of course, were the other children born after marriage, by its father's surname. Never once in the course of its life had it been known by the mother's surname. The banns of its marriage had been published in the father's name, when it suddenly came to the knowledge of the clergyman that its birth was illegitimate, and he insisted in republishing the banns in the mother's surname. A more unjustifiable act can hardly be conceived. But such officious and illegal interference is not uncommon. Bans of marriage and notification to the public ought to be published in the name by which the person is ordinarily known, or they defeat the very purpose for which they exist. An illegitimate child is generally brought up in the family of the mother, and therefore is usually known by the mother's surname. But there is nothing in law, nor is there any custom enforceable in law, which requires a bastard child to take its mother's surname. There is nothing beyond the circumstance that in most cases that eventually proves to be the surname acquired by reputation. If the circumstances prove that the reputation is in another name, the father's, for example, or the surname of a parent by adoption, then the child has as much or as little, whichever it may be, right thereto as it would have had to the mother's name. Upon baptism the child acquires an absolute right to whatever names have been given in baptism. There is no reason in law or custom why an illegitimate child needs any surname over and above its baptismal names. A single baptismal name would not in practice be found sufficient for ordinary purposes. But when two or more names are given, there is not the least necessity for the addition of anything further. The obvious corollary of this assertion is the advice to first decide what surname it is desired that the child should be known by in after life, and to give that surname as the last baptismal name. The argument upon which much discussion is based that obviously a child must have a name is fallacious as thus put, for we know of no law or custom which, in opposition to the repute commenced and adhered to by the child's relatives, and adhered to by the child itself on reaching years of discretion, can fasten upon the child a name he has not inherited and disclaims. Providing the filiation can be indubitably proved, and stringent proof is always required, a royal license can usually be obtained to assume and take the surname of the father, or else to continue to use that surname, if the reputation has been acquired therein. A royal license is equally necessary and equally obtainable to use the mother's name, though we are aware of no precedent of a case dealing with the name only and having no reference to the arms. Nor are we aware of a precedent of a royal license to a bastard to take the name of a more remote ancestor, but it seems an obvious and logical conclusion that, if on proof of filiation from one person from whom no inheritance can be alleged, a royal license is obtainable, it should be equally available for the name of another. But royal licenses being no more than matters of grace and favor, no one can demand that favor as a right, no matter how logical may be the basis of the request. Therefore, if the Crown prefers to refuse,